Hello, my name is John P.L.L.C. I'm with the P.L.L.C. Law Firm in West Palm Beach, Florida. We handle estate and business litigation and the administration of estates and trusts, as well as guardianship litigation and related matters. And I'm going to be speaking to you today about trust lawsuits in Florida and the renunciation rule. Specifically, there are 3 cases that you must read if you are a beneficiary who receives an inheritance under a Florida trust and is suing to get relief, including the relief of overturning or voiding a particular trust, a trust amendment, or a restatement of that trust. So your typical example might be a son of somebody who creates a revocable trust in Florida is a beneficiary for, say, 60% under one version of the trust, and a couple of years later, the inheritance is reduced to 30%. And then a couple of years later, the inheritance under the revocable trust is reduced to 10%. The grantor passes away, and so now this child has seen a decrease in their trust inheritance from their parent under the revocable trust. And they find issue with that, and they find something wrong with that. And they believe that the trust amendments, which reduce their trust inheritance under the parent's Florida estate plan, is improper, it's invalid. And so they file a trust challenge, right? They file a petition or a trust lawsuit seeking to have the trust amendment or amendments declared void or invalid for any number of reasons. Could be undue influence, could be lack of capacity, could be any number of things. And so one of the rules that we have, a procedural rule in Florida, is the renunciation rule. And from a defense practice standpoint, those who are those probate and trust litigators who are upholding trusts, who are defending trust documents and trust amendments, and who are defending trustees, you need to be mindful of this from a procedural as well as a tactical standpoint. There's an equitable doctrine of renunciation in Florida. And the issue is, if I'm going to object to a will or a trust, do I have to first renounce the benefits of that will or that trust? And the general rule is yes, you do. This Gossett case, G-O-S-S-E-T-T, Gossett v. Gossett, 182 Southern 3rd 694, issued by Florida's 4th District Court of Appeal on December 16, 2015, says, sure, we understand the renunciation rule, but you generally don't have to renounce that which you're going to inherit anyways. So in our little example that I just made up here, the 60-30-10 rule, you used to get 60% of the trust, then you got 30, it was reduced further to 10% later on, right? You shouldn't have to renounce 10% because if you prevail on having that last trust amendment invalidated, you're going to get more than 10%. So the takeaway from this is, if you are a trust litigator in Florida, or you're involved in trust litigation in Florida, and particularly if you defend trustees, or you're a trust lawyer who's going to defend an attack on a trust, you need to read the Gossett case, and you have to consider whether the plaintiff, the petitioner, has complied with the renunciation rule in light of the Gossett case. And there's 2 other cases that you want to read. You need to read the Barnett National Bank of Jacksonville case, 49 Southern 2nd 535. It's a Florida Supreme Court case from 1950 that really, for years, that was the case that we used to discuss the renunciation rule until 2013, when the FinTAK case came along, F-I-N-T-A-K. 120 Southern 3rd 177. That's from the 2nd District, a 2013 case that expanded on the renunciation rule. And so Gossett, FinTAK, and Barnett National Bank of Jacksonville, those 3 cases should be read anytime you have trust litigation in Florida, and specifically when a beneficiary under a Florida trust is going to try to invalidate or attack or file a petition to set aside a particular trust amendment or a trust document or a restatement or someone's revocable or living trust. That concludes my remarks on the renunciation rule in the context of trust litigation in Florida.